Okay, good day everyone. I am J. Mark D. Bukog from BS Criminology 3 Delta. For the continuation of our audiovisual reading, let's proceed to Activity 8B. Preliminary title. Let's proceed to number 4. Number 4, Similia Alimenticia into Cereal in Article 303. Number 5, filed in third paragraph of Article 344, which is not found in the Spanish text. Okay, let's proceed to Article 4. Article 4. Article 2, application of its provision except as provided in treaties and laws of preferential application. The provision of this code shall be enforced not only within the Philippines archipelago, including its atmosphere, its interior waters and maritime zone, but also outside of its jurisdiction against those who, number 1, uh, should commit an offense while on the Philippine ship or airship. Number 2, should forge or counterfeit any coin or currency, note of the Philippine Islands, or obligations and securities issued by the government of the Philippines. Number 3, should be liable for acts connected with the introduction into these islands of the obligations and securities mentioned in the preceding number. Number 4, while being public officer or employees should commit an offense in the exercise of their function, or number 5, should commit any of the crimes against national security and the law of nations defined in Title 1 of Book 2 of this code. In what cases are the provisions of the revised penal code applicable even if the felony is committed outside of the Philippines? See Article 2, Revised Penal Code. The crimes that may be committed in the exercise of public function are directly bribery. Article 210. Article bribery in Article 211, frauds against the public treasury. Article 213, possession of prohibited interest, and 216, malversation of public funds or property. Article 217, failure of accountable officer to render accounts. Article 218, illegal use of public or property. And Article 220, failure to make delivery of public funds or property. Article 221, the and falsification by the public officer or employee committed with abuse of his official position in Article 171. Okay, let's proceed to the crimes that against the national security and the law of nation are treason. Article 114. Conspiracy and proposal to commit treason. Article 115. Espionage. Article 17. Inciting to war and giving motive for reprisals. Article 118. Violation of neutrality in Article 19. Correspondence with hostile country in Article 120. Flights to enemy's country, Article 121. And piracy and mutiny on the high seas in Article 122. The crimes punishable in the Philippines under Article 2 is cognizable by the regional trial court in its original jurisdiction, which the charge is filed. Important words and phrases in Article 2. This is the important words. Okay? Number 1, except as provided in the treaties and laws of preferential application. like the base agreement between the Republic of the Philippines and the United States of America and the provisions of RA 75. Number 2, its atmosphere, the sovereignty of the subjacent state, and therefore its penal laws extend to all the air space which covers its territory, subject to the right of way or easement in favor of foreign aircrafts. Number 3, interior waters. The phrase interior waters includes creeks, river, lakes, in bays, gulfs, and straits covered cobs, coves, inlets, and road strip lying wholly within the 3-mile limit. Number 4, the maritime zone. The states, by means of treaties, have fixed inland to 3 miles from the coastline. Starting from the watermark, it includes those bays, gulfs, adjacent parts of the seas or recesses, and the coastline whose width in their entrance is not more than 12 miles measured in straight line from headline to headline, and all strait of less than 6 miles wide for those straits having more than that width. The space in the center outside of the marine league limits is considered as open sea. Number 5, cyberspace, the online world of computer network and the internet. Crimes on board foreign merchant ship or airship, just as a merchant ship is an extension of the territory foreign. Offense committed on board a foreign merchant's vessel while on the Philippine waters is triable before the court. Let's go to next page, the page 13 in the book. Rules as to jurisdiction over crimes committed aboard foreign merchants' vessels. Finch rule. Such crimes not triable in the courts of the country, unless their commission affects the peace of security and territory of safety of the state is endangered. The English rule, such crimes are triable in that country unless they merely affect things within vessel or property, or they refer to the internal management thereof in this country. The English rule is observed. The French rule. Jurisdiction has never been admitted or claimed by Great Britain as a right, although she has subsequently conceded to it by treaties. Note that all must concede that felonies homicide is a subject for the local jurisdiction, and that if the proper authorities are proceeding within the case in the regular way, the consul has no right to interfere to prevent it. Mere possession of opium aboard a foreign merchant vessel in transit in is not triable in Philippine courts, because that fact alone does not constitute a breach of public order. The reason for this ruling is that mere possession of opium on such a ship without being used in the territory does not bring about this in this country those disastrous effects that the law contemplates of avoiding. But said courts acquire jurisdiction when the 10 of opium are landed from the vessel of the Philippine soil. Landing or using opium is an open violation of the laws of the Philippines. When the foreign vessel, merchant vessel is not only transit because of the Philippines is terminal ports, the Philippines is its terminal ports, the person in possession of opium on board that vessel is liable, because he may be held guilty of illegal importation of opium. Smoking opium constitutes a breach of public order. Philippine courts Philippine courts have no jurisdiction over offenses committed on board foreign warship in territorial waters. And people Wongxing 48 Philippines 729. Okay, let's go to next. Warship are always reputed to the territory of country to which they belong and cannot be subjected to the laws of another state. A United States Army transport is considered a warship. Let's go to next page of our book. Title 1, Felonies and Circumstances which Affect Criminal Liability. Chapter 1, Felonies. And Article 3, Definitions. Acts and omission punishable by law are felonies or the delitos. Felonies are committed not only by means of deceit or dolo, but also by means of culpa or fault. There is deceit when the act is performed with deliberate intent, and there is a fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. Felonies defined Felonies are acts or and omission punishable by a revised penal code. The elements of felonies in general are: number 1, that there must be an act or omission. Number 2, that the act or omission must be punishable by a revised penal code. Number 3, the act is performed or omission incurred by means of dolo or culpa. Okay, that's it. The elements of felonies. 3 elements. Okay, let's go to another topic. The important words and phrases in Article 3. Meaning of the word act. By act must be understood any bodily movement tending to produce some effect in the external world, it being unnecessary that the same be actually produced, as the possibility of its production is sufficient. But the act must be one which is defined by revised penal code as constituting as a felony. That's in the page 14. Oh, let's go to another page, page 15. Or at least an overt act, that felony, that is an external act which has direct connection with the felony intended to be committed. Only external or overt act is punished. Only external and overt act is punished. A criminal thought or mere intention, no matter how immoral or improper it may be, will never constitute a felony unless there is an overt act. Meaning of the word omission. By omission is meant inaction, the failure to perform a positive duty which one is bound to do. There must be a law requiring the doing or performance of an act. Example of felony by omission: anyone who fails to render assistance to any person whom he finds in an uninhabited place, wounded, or in danger of dying, is liable for abandonment of person in danger. That was an example of felony by omission, number 1. Okay, let's go to number 2. An officer entrusted with collection of taxes who voluntarily fails to issue a receipt as provided by law is guilty of illegal exaction. Number 3, every person owing allegiance to the Philippines without being a foreigner and having knowledge of any conspiracy against the government, who does not disclose and make known the same to the proper authority, is liable for misprision of treason. And Article 116. Note that is felonies by omission. There is a law requiring a certain act to perform and person required to do act fails to perform it, the omission must be punishable by law. Yes, it will be punishable. Because there is no law that punishes a person who does not report to the authorities the commission of a crime which he witnessed. The omission to do is not a felony, failure to report the crime of arson. See also covering or hiding the facts or effects of the crime such as misprision of treason, accused, concealed, or does not disclose the crime in Article 116 Revised Penal Code, and the case of accessories who profit from effects of the crime are essential elements. Act, meaning of act, an overt or external act. Omission, failure to perform a duty required by law, such as failure to render assistance to anyone who is in danger or of dying or is in inhabited large or wanted. Abandon of a person in danger to be considered as a felony. There must be an act or omission, mere imagination, no matter how wrong, does not amount to a felony. An act refers to any kind of body movement that produces change in the outside world. In felony by omission, however, there must be a law requiring the doing or the performance of an act. Thus, mere passive presence at the scene of the crime, mere silence, and failure to give the alarm without evidence of agreement or conspiracy is not punishable. Felonies, acts, and omission punishable by revised penal codes. Offense, crimes punished under special law. Misdemeanors, minor infraction of law such as violation of ordinance. Crime, acts, and omission punishable by any law. How felonies are committed. Number 1, by means of deceit or dolo. There is deceit when the act is performed with deliberate intent. Requisites. Number A, letter A. Freedom. B, intelligence. C, intent. Example, homicide, rape, murder, treason, and robbery. Number 2, by means of fault or culpa. There is a fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. Imprudence means delinquency of action. Uh, A, A was driving a truck along a road. He hit B because it was raining. Reckless imprudence. Requisites, negligence, deficiency of perceptions, failure to foresee impending danger usually involves lack of foresight. 1, it needs freedom. Number 2, intelligence. That's it. Number 3, imprudence, negligence, lack of skill or foresight. Number 4, lack of intent. Voluntariness comprehends the concurrence of freedom of action, intelligence in the fact that act was intentionally, and culpable felonies there is no voluntariness if either freedom, intelligence, or imprudence. Negligence, lack of foresight, or lack of skill is lacking without voluntariness. There can be no dolo or culpa, hence there is no felony. Criminal intent. Criminal intent is dolo. Dolo means intention, dolo. In criminal law, intent is categorized into 2. Number 1, general criminal intent. Number 2, specific criminal intent. Criminal intent is not necessary in these cases. Number 1, when the crime is the product of culpa or negligence, reckless imprudence, lack of foresight, or lack of skill. Number 2, when the crime is prohibited under a special law or what is called a malum prohibitum. Distinction between intent and discernment. Intent is the determination to do certain things, an aim or purpose of the mind. It is designed the result of or determination by which a person acts. On the other hand, the discernment is the mental capacity to tell right from wrong. It relates to the moral significance that a person ascribes to his act and relates to the intelligence as an element of dulu. Distinction from intent. Distinction between intent and motive. Intent is demonstrated by the use of particular means to bring about a desired result. It is not a state of mind or a reason for committing crime. If crime is intentional, it cannot be committed without intent. Intent is manifested by instrument used by the offender. Let's go to next page. The specific criminal intent becomes material if the crime is to be distinguished from attempted or frustrated stage. Mistake of fact is a misapprehension of fact on the part of the person who caused injury to another. He is not criminally liable. Requisites. Number 1, that the acts done would have been lawful. Have the facts been as the accused relieved them to do. Number 2, the intention of the accused is lawful. Number 3, the mistake must be without fault or carelessness. Example, Chong, being afraid of bad elements, locked himself in his room by placing a chair against the door. After having gone to bed, he was awake by somebody who was trying to open the door. He asked the identity of the person, but he did not receive a response. Fearing that this intruder was a robber, he leaped out of bed and said that he will kill the intruder should be attempt to enter. At that moment, the chair struck him. Believing that he was attacked, he seized a knife and fatally wounded by the intruder. That's the example of the mistake of fact. Okay, let's go to mens rea. The technical terms mens rea is sometimes referred to in common parlance as the gravamen of the offense. Mens rea of the crime depends upon the elements of crime. One can only detect the mens rea of the crime by knowing the particular crime committed without reference to a particular crime. This term is meaningless. For example, in rape, the mens rea is carnal communication. Theft, the mens rea is the taking of property of another with intent to gain. And falsification, the mens rea is the affection of the forgery with intent to pervert the truth. It is not merely writing something that is not true. The intent to pervert the truth must follow the performance of the act. Election law is a special law and violation of which is mala prohibita. It is Hornbook doctrine that in mala prohibita crimes the only inquiry is whether the law has been voided. When the act is illegal, the intent of the offender is immaterial. Okay, that's it. Let's go to page 19. Second to the last page. Okay, the difference between mala in si and mala prohibita. Okay, mala in si. is a felonious act committed by means of dolo or culpa as defined in the revised penal code, while mala prohibita is a felonious act defined in special law. The driver may invoke the concept of sudden emergency rule as a defense when one suddenly finds himself in a place of danger and is required to act without time to consider the best means that may be adopted to avoid the impending danger is not guilty of negligence if he fails to adopt what subsequently and upon reflection may appear to have been a better method unless the emergency in which he finds himself is brought about by him by his own negligence. Article 4 Criminal Liability. Criminal liability shall be incurred: number 1, by any person committing a felony or delito, although the wrongful act done by different from that which he intended. Number 2, by any person performing an act which would be an offense against person or property were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffective means. Application of Article 4 Criminal Liability is incurred by any person in the cases mentioned in the 2 paragraph of Article 4. This article has no reference to the manner criminal liability is incurred. The manner of incurring criminal liability under the revised penal code is stated in Article 3, that is performing of failing to do an act when either is punished by law by means of deceit with malice or fault through negligence or imprudence. One who commits an intentional felony is responsible for all the consequences which may naturally or logically result therefrom, whether foreseen or intended or not. In view of Article 4, Part 1, a person committing a felony is criminally liable although the consequences of his felonious act are not intended by him. Mistake is in identity or error in persone means inflicting injury upon another person who is mistaken for another. Okay, let's go to last page 20. Compendia of Revised Penal Code, Book 1 and Book 2. Okay, example, A intended to kill B, but it was C whom he shot because he was mistaken C to be B. He was mistaken. Then, yes, he was mistaken. Okay, let's go to another topic. Mistake in the blow or aberratio actus means hitting somebody other than the target due to lack of skill or fortuitous instance. Example, A wanted to kill B using firearm. He shot B, but it was C who was injured because the gun he used is a Paltic, which accuracy in hitting the target is not reliable. Preter intentionem means the injury's result is greater than that intended or expected by offender. Example, A only wanted to punch B and inflict physical injuries. However, B was hit on the side of the face. B fell on the pavement, his head hitting the concrete floor, resulting a brain hemorrhage that caused of his death. That's it. Okay, let's go to Article 5, Duty of the Court and connection with acts which should be repressed but which are not covered by the law, and cases of excessive penalties. Whenever a court was knowledge of any act which it may deem proper to repress and which is not punishable by law, it shall render the proper decision and shall report to the chief executive through the Department of Justice the reason which induced the court to believe that said act should be made the subject of legislation. In the same way, the court shall submit to the chief executive through the Department of Justice such statement as may be deemed proper without suspending the execution of sentence when a strict enforcement of the provision of this code would result in the imposition of a clearly excessive penalty, taking into consideration the degree of malice and the injury caused by the offense. Okay, let's go to another topic. The no crime unless there is a law punishing it. In Latin words, nullum crimen nollia pena no sine lege. Okay, again, nullum crimen nolla pena sine lege. No crime where there no law is punishing it. The law as a general rule looks forward, not backward. Yeah, look forward, not backward. Okay, let's go to Article 5. Article 5 covers two situations. The court cannot The court cannot convict the accused because the act do not constitute a crime. The proper judgment is acquittal, but the court is mandated to report to the chief executive that said act he made subject of penal legislation and why. Number 2, where courts finds the penalty prescribed for the crime is too harsh considering the condition of surrounding the commission. Okay, that's it from page 11 to 20 in our activity 8B. Thank you so much, sir. God bless.